I don't understand. You have you've never completed your high school education. You have no driver's license, no job. And with your criminal history, you're not exactly a great role model for your children who you have custody of none of.
I have custody of Caden.
Who's in custody himself, right?
Yes.
Right. In the state of Ohio versus Chelsea Teagarden. Ms. Teagarden is before the court with her counsel, Mr. Kidd. Ms. Tranter, on behalf of the state of Ohio, we're here for sentencing. There was a pre-sentence investigation. Mr. Kidd, you've had an opportunity to review.
Your Honor.
Ms. Tranter, anything on behalf of the state?
Your Honor, just to, in addition to our discussions in chambers, there was is a restitution request in this case for the court's information, $4,198.74 for car repairs, damage done to the vehicle. The victim being Jesse Carter.
All right. Anything else?
Nothing further.
Mr. Torek, anything from probation?
Nothing further, Your Honor.
Mr. Kidd.
Your Honor, in regard to Ms. Teagarden, I know it's been a rocky period of time for her. She has made some real efforts. She's had some real challenges as well. Your Honor, we know what the recommendation of probation is. Yeah, we're supportive of that recommendation. I've talked to her about the 1 to 5 assessment as to her need for treatment. Not sure what that meant or where it came from, but she very much knows that she does need treatment. I think she's communicated that to the court through letters, that she has sought some sort of treatment program at the coach or otherwise, wherever the court might be. Your Honor, she's never been to prison before. This last failure to appear actually wasn't a failure to appear, but the revocation of her bond. She was dealing with her son, who had a significant charge as a juvenile delinquent in Butler County. She was trying to manage that to some extent, try to spend some time with him, and she simply did not provide the priority to her own case that she knows that she should have done. Your Honor, she knows she came in, that she tested positive. She knows she has a drug issue.
I even wrote him in my P.
And you'll have a chance to talk to the judge as well. But we are requesting that she be placed on community control, that she be able to follow the recommendation of probation. So that's what we're asking. I know she wants to talk to you as well.
Ms. Teagarden, anything you want to say?
Yes, sir. When I was released for the PSI, my son was also on PSI, and I really thought I could handle both of them at the same time and got overwhelmed. When Mr. Brown asked me to come in to see him, I got scared because I couldn't get a ride the first day that he wanted to see me. And the second day when he called me, I just didn't answer because I was scared that he was going to lock me up because I missed the first day. I just didn't come because I wanted to be there for Caden and his court dates. And because I'm all he's got. But now that he's sentenced, I know he's doing 6 to 9 months. And he'll be released at the end of November, beginning of December. And I just want to be a part of his rehabilitation as well as mine. And I did say in my PSI that the coach had evaluated me and told me that I could probably benefit from treatment. And I would like to go to treatment or have the opportunity to please go to treatment before going to prison.
Ms. Teagarden, this always confounds me when someone says they know they need treatment, and here we are, this case has been pending for some time, and yet you have never sought treatment. I don't know what, if you, ma'am, please. Is there something else you want to say to me? Then say it now.
Yes, sir. They came to evaluate me, not this time, but the last time I was in here, because I reached out to peer support to ask for the coach to come see me.
Okay, and then since that time, you had been released from the county jail, correct?
Yes, sir.
Did you engage in treatment when you were released?
I was dealing with my baby's PSI.
Okay, and you see, that's my point. You had an opportunity, if you wanted treatment that you now are telling me you desperately need. You could have. It's like, what are you waiting for? You waiting for me to order it? I don't understand. You've never completed your high school education. You have no driver's license, no job. And with your criminal history, you're not exactly a great role model for your children who you have custody of none of.
I have custody of Caden.
Who's in custody himself, right?
Yes.
Right. Oh, so you just proved my point. Ms. Teagarden, I gave you 3 opportunities on pretrial. The last one was disastrous because you not only didn't show up, didn't do anything, knowing that I was going to sentence you in a few weeks because I released you on February the 9th, the day that you entered a plea. I gave you an opportunity to prove to me that you, in fact, could comply with the rules and orders of the court. And you didn't do it. And not only did you not do it, didn't show up for your interview, didn't show up for your assessment, didn't follow the rules of your supervision. On top of all, is there something else you want to say?
I did my assessment. I did go to him the first time that I was supposed to go to him. I only didn't go the second time.
Okay. You didn't complete your assessment. That's what you're making my point for me.
I did it. He did
Ms.
it.
Teagarden, I'm done. You also, on the last time, tested positive for methamphetamine, amphetamines, and MDMA, correct?
Yes, sir.
All right. Court's considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevance, seriousness, and recidivism finders. The court does find that you are not amenable to community control and that prison is necessary to fulfill the purposes and principles of sentencing due to your extensive criminal history, your failure to respond to any of the court's conditions and your pretrial supervision. So at this time, the court is going to order you to serve 9 months in prison. You have 80 days jail time credit. Ms. Tranter, did you give me a number for the restitution?
I did, Your Honor. I can give it to you again, though.
Yeah, we would object to that. So we would request a hearing on restitution.
How soon can we set that?
I'm not sure because the victim is out of state, so I'd have to see when he can make arrangements.
All right,
to
set
do
the
that.
restitution for hearing. Other than the restitution, the court does find that she's indigent for the purpose of other fines, costs, or financial sanctions. You're also subject to a discretionary period of post-release control, which means when you are released from prison, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can be provided to you. Ms. Tranter, is there anything else?
No, sir.
Mr. Kidd?
No, Your Honor, thank
That's
you.
all. Thank you.
The case before the court was that of the state of Ohio versus Chelsea Teagarden, who appeared for sentencing alongside her defense counsel, Mr. Kidd, while Ms. Tranter represented the state of Ohio. The proceedings began with the judge already expressing his frustration with the defendant's situation, pointing out that she had never completed her high school education, had no driver's license, held no job, and carried a criminal history that made her far from an ideal role model. When Chelsea attempted to argue that she did have custody of her son, Caden, the judge immediately shut that down by pointing out that Caden himself was currently in custody as a juvenile, which the defendant acknowledged was true. The prosecutor, Ms. Tranter, addressed the court briefly, noting that in addition to the discussions that had already taken place in chambers, there was a restitution request in the case. The amount being sought was $4,198.74, which covered the cost of car repairs and damage done to a vehicle belonging to the victim, Jessie Carter. After presenting this figure, the prosecutor indicated she had nothing further to add. The probation officer, Mr. Tork, also confirmed he had nothing further to present to the court at that time. Defense attorney Mr. Kidd then took the opportunity to speak on behalf of his client. He acknowledged that it had been a rocky period of time for Chelsea and that while she had made some real efforts, she had also faced significant challenges along the way. He referenced the probation department's recommendation and stated that he was supportive of that recommendation. He mentioned that Chelsea had been evaluated under a 1 to 5 assessment regarding her need for treatment, and that although she had not fully understood what the assessment meant or where it came from, she was fully aware that she needed treatment. He noted that she had communicated this to the court through written letters and had expressed a desire to seek some sort of treatment program, whether through a particular coaching program or wherever the court might direct her. Mr. Kidd further argued that Chelsea had never been to prison, before and tried to contextualize her most recent failure to appear, clarifying that it was not simply a straightforward failure to appear, but rather stemmed from the revocation of her bond. He explained that at the time, Chelsea had been dealing with her son, who was facing a significant charge as a juvenile delinquent in Butler County. She had been trying to manage that situation and spent time with her son, which led her to not give the appropriate priority to her own legal case, something she fully recognized and regretted. Her attorney pointed out that Chelsea herself had acknowledged testing positive for drugs and was well aware that she had a substance abuse issue. He concluded his remarks by formally requesting that Chelsea be placed on community control and asked that the court follow the recommendation made by the probation department. He then invited Chelsea to speak directly to the judge. Chelsea Tigard then addressed the court herself. She explained that when she was released for the pre-sentence investigation, her son was also on a pre-sentence investigation at the same time, and she genuinely believed she could handle both situations simultaneously. She admitted that she became overwhelmed. She spoke about the moment when her probation officer, Mr. Brown, had asked her to come in and see him. She said she could not get a ride on the first day he wanted to meet with her, and on the second day when he called, she did not answer the phone because she was scared he was going to lock her up due to having missed the first appointment. She admitted she simply did not go to see him because she wanted to be present for her son Caden during his court dates, stating that she felt she was all he had. She then updated the court on her son's situation, noting that he had since been sentenced to 6 to 9 months and was expected to be released at the end of November or beginning of December. She expressed that she wanted to be a part of his rehabilitation process as well as her own. She also referenced her pre-sentence investigation report, in which she had noted that a coaching program had evaluated her and told her she could likely benefit from treatment. She pleaded with the court to give her the opportunity to go to treatment before being sent to prison. The judge responded to Chelsea's statement with visible frustration and confusion. He told her that it always confounded him when someone claimed to know they needed treatment and yet had done nothing about it, especially when the case had been pending for a significant period of time. He pointed out that despite all that time, she had never actually sought out treatment on her own. Before he could finish his thought, Chelsea appeared to interrupt or attempt to respond, and the judge firmly told her that if she had something else to say, she should say it now. Chelsea then clarified that during a previous time she had been in the jail, she had reached out to peer support and asked for the coaching program to come and evaluate her. The judge acknowledged this, but then pressed further, asking whether she had engaged in any treatment after she had been released from the county jail. Chelsea began to explain that she had been dealing with her son's pre-sentence investigation, but the judge cut her off and told her that was precisely his point. He stated that she had been given an opportunity to seek the treatment she was now claiming she desperately needed, and she had not taken it. He expressed that he could not understand what she had been waiting for, asking whether she had simply been waiting for him to order it. The judge then went on to lay out Chelsea's circumstances in stark terms. He reiterated that she had never completed high school, had no driver's license, no job, and a criminal history that meant she was not a positive role model for her children, none of whom were in her custody. When Chelsea again insisted that she had custody of Caden, the judge once more pointed out that Caden was himself in custody, and she confirmed this was correct. The judge told her that this only proved his point further. He then went on to describe the opportunities he had already extended to Chelsea prior to this sentencing hearing. He told her she had been given 3 opportunities during the pretrial phase and that the last one had been disastrous. He explained that he had released her on February the 9th, the same day she entered her plea, specifically to give her a chance to show him that she could comply with the rules and orders of the court. Instead of doing so, she had not shown up for her interview, had not shown up for her assessment, and had not followed the rules of her supervision. The judge asked if there was anything else she wanted to say. Chelsea then pushed back, insisting that she had completed her assessment and that she had gone the first time she was supposed to go and had only missed the second appointment. The judge responded that she had not completed her assessment, but Chelsea continued to argue that she had in fact done it. The judge cut her off entirely, telling her he was done hearing from her. He then added that at her most recent appearance, she had tested positive for methamphetamine, amphetamines, and MDMA, and asked her to confirm this. Chelsea confirmed it was correct. With that, the judge moved to deliver his ruling. He stated that the court had carefully considered all the statements made during the hearing, the pre-sentence investigation report, and the purposes and principles of sentencing, including the relevant seriousness and recidivism factors. Based on all of this, the court found that Chelsea Tagart was not suitable for community control and that a prison sentence was necessary in order to fulfill the purposes and principles of sentencing. The judge cited her extensive criminal history, her failure to respond to any of the conditions set by the court, and her conduct during pretrial supervision as the primary reasons for this conclusion. The court ordered her to serve 9 months in prison with credit given for 80 days she had already spent in jail.